Hello, everybody. Welcome to the National Inventor Club. I'm your host, Brian Freed, and I'm excited to share our amazing lineup of intros and guest speakers and the premium members of National Inventor Club. We're going to have an after-meeting networking event. So stick around. It should be about an hour or so. You're going to learn great information as an entrepreneur, startup, inventor, to be able to put your mind with setting yourself up with getting past your limiting beliefs with Bob Quintana. We have Dale Miller. He's one of our new National Inventor Club members, premium members. And we have the Small Business Development Center and the US Patent and Trademark Office on. So I'm going to introduce everybody in a second, but I wanted to welcome everybody to 2022, 23 now. It's going to be an amazing year. Look at how fast 2022 went. We're in 2023. So we have some great guests lined up for the months to come. So please, if you haven't already, sign up as a premium member of National Inventor Club or a free member to keep in touch with us. We also have a newsletter that we put out, a monthly newsletter. So if you're a member, free or paid, you'll also be included in that the newsletter that goes out every month as well. So we're doing whatever we can here. I'm working hard to get the information out to you so it can keep you moving forward with your invention ideas. So let's get the meeting started tonight. Okay, so let's put up Pierre Lespinas. He's from the Small Business Development Center. He is SBDC, otherwise known, and he's a business advisor from Farmingdale State College in New York, who's a very great supporter and partner sponsor for National Inventor Club. So Pierre, thank you. And you have some tips and some resources for us to share?
Yes. I'm very excited to be attending this meeting. As always, there's a lot of information to be shared, and hopefully I can contribute something of substance to the viewership. Here's the three tips that I have for the audience tonight. Obviously, there's probably people in the audience at various stages of developing their products or becoming a startup and being new at entrepreneurship. However, whether you're a beginner, you're just beginning development, you're an entrepreneur, whatever the stage may be, it is not too early to start considering these three essential things. The first one is just thinking about it. You're not going to have perfect information, but it's never too early to think broadly about capital requirement. How much money is it going to take for you to launch and monetize this idea that you have broadly? You start with very imperfect information, but as time goes on, as you acquire more knowledge, as you have more data, you can perfect the estimations. But you need to start thinking about that as early as possible. Capital requirement. The second tip is about scalability. You ought to start very early at the earliest stages of asking the question, is it something that can sell 1,000, 1,000,000, 10 million? What do you think? Of course, with your enthusiasm, you will probably start with some very wild estimation. But believe me, those estimations are usually tempered as you start gathering statistics. You start gathering reliable data. I'm sure you'll come back somewhere that is closer to reality if you weren't there before. The third thing you should think about, and that's for everybody, that is critical, is bootstrapping. Usually that's what has to happen. You may have to bootstrap this business on your own, scrapping savings and doing stuff. Maybe you can do it, maybe you can't do it, but this is definitely something that you start to think about rather early. So capital requirement, scalability, and possible bootstrapping.
Thank you, Pierre. I have to say that the Small Business Development Center is a resource for inventors, entrepreneurs, startups. You can find a local Small Business Development Center, which is actually a division of the SBA, Small Business Administration. You can find them all over the country. Most of them are found in colleges, in college campuses, and they can help you with business plans, connecting up with local resources, grants, different opportunities out there. They're really tapped into the neighborhood that can really connect you with things that you need to continue moving your business and your ideas forward. Business plans they'll help you with if I didn't mention that. So, Pierre, how much does all that cost?
Well, the grand total of $0. But and to be perfectly truthful, to the extent that you're a taxpayer, you've probably contributed to it in other ways. But in terms of what we charge, there is no limit to the amount of time we spend with people. The more enthusiastic you are, the more enthusiastic we get. And
Thank you so much.
it's not for nothing. Right.
Pierre, good information as always. Tell Erica we say hello, and we'll see you again soon. Thank you,
Okay.
Pierre, from the Small Business Development Center, business advisor at Farmingdale State College in New York. Thank you again.
Bye-bye.
Bye-bye. All right, let's put Stephen Yanchuk on. He is from the US Patent and Trademark Office. Whoop, I think I got his presentation up for a second, but let's see if we can put him up first. Where are you? Where are you, Stephen? There you are. How you doing?
Doing fine over here.
So Stephen is from the Eastern Regional Outreach Office of the US Patent and Trademark Office, and they're responsible for getting great information out to the inventors, and we're always honored to have somebody from your office and you tonight representing the US Patent and Trademark Office on National Inventor Club. So if you can help us with some information from the USPTO, that would be great.
Sure, of course. And yeah, that's exactly what we do over here at the Eastern Regional Outreach Office. We connect with large institutions as well as people that are just starting out in their intellectual property ecosystem journey. So really, how do we engage the breadth of that full spectrum? The agency just launched this Women's Entrepreneurship Symposium late last year. And our team had the ability to help reinforce that effort by setting up an event in our region down in Naples, Florida. At this event, here I'll put some links in the chat. So the links are for the Women's Entrepreneurship Symposium, but then also the links for Kathy Vidal and the new Commissioner for Patents, Vishali Udupa. We also, during this event, were able to showcase for the first time the intellectual property identifier tool. That's probably the most important link that's in this chat link over there, because what it allows you to do is to be able to put what your resources are. What are you developing? What have you made? What does your company hold in terms of brand identifiers, and what are you working towards? And then it helps identify whether you should seek copyright protections, trademark protections, or even patent protections. You know, as we like to say here, IP portfolio is a business portfolio. We see the growing trends of valuations for the intellectual property holdings of companies being even more important as time goes by. And so, you know, take a look at that brand new tool. One of the contributions that members of our team have done in the past 2 years is to take all of our outreach materials and convert them into Spanish. And in that vein, we were able to really help push to make sure that this intellectual property identifier tool also has the ability to be in Spanish as well. So I'm going to stop sharing my screen. And then I wanted to talk about one more initiative that's coming up. One more upcoming event is our AI and ET partnership that we have. And we have an upcoming event. It's the third in the series. And that's coming up on February 2nd. It's going to discuss AI-driven innovations. What is the current state of play? AI inventorship and the unanticipated IP challenges from AI-driven innovations. These are topics that I find fascinating, and I haven't even scratched the surface of what this world can be like in a couple of years. I know everybody's buzzing about Chat GPT right now and DALL-E. And this is more of those efforts. What's going on behind the scenes to make sure that everyone's intellectual property is protected and that everybody operates on an even playing field. And so I encourage everybody to take a look at these upcoming events and initiatives. And that's what I got for you today.
Thank you very much, Stephen. If you don't mind, if you can, when you're going into the social media streams, if you can put the links in there, that would be great I have it in the private chat, but I want them to have the links also. So, but at the same time, the inventors and all the audience can go on uspto.gov and they can go into the events section or the inventor section. And there's a lot of great resources there that you mentioned that are within that area, right?
That's exactly right. And when you go on and you register for a specific event, such as, previously we had the blockchain and IP series. Now we have these AIET partnership events. When you register for one event, you will get notified of upcoming events or recordings. And so once you're in that ecosystem, we use Eventbrite for the recordation of that.
Okay.
You'll be notified of the other events that are coming up, but not all of our upcoming events that we host here at the USPTO. So they are kind of categorized. So that's also something to be aware of.
Very much. Thank you for that information, Stephen. Thank you for taking time. And we thank the US Patent and Trademark Office for always being a monthly contributor to the meetings that we have here at National Inventor Club. So thank you for doing what you do, and we will keep in touch. From your office, tell Elizabeth we say hello, we miss her. And I know that Matthew Bryan, our guest this evening, is a referral from Elizabeth. She connected us up to be able to have Matthew Bryan from WIPO on. So thank you for your help.
Have a great podcast, Brian. We love being here. Take care.
You too. Thank you. All right. So now I have Bob Quintana. I'm still trying to figure out how many years it's been that we've known each other. Bob has helped me in the past, and I've been involved in following him for a long time. Listen to this, guys and ladies. Bob he's been people have heard of Tony Robbins. He worked closely with Tony Robbins for 14 and a half years as the president of Anthony Robbins and Associates. And he was the #1 independent affiliate worldwide. And he personally built a team of over 20 full-time employees and agents, and he sold that business. And he's also led and taught Tony's seminars with many companies that he's had the opportunity to work with. And we have him tonight here. I'm talking tens and thousands of people. You've seen those big webinars and seminars out there. Bob was in the front stage helping and growing companies. And I'm proud to have Bob with us. He's going to be an active intro kind of information for us to help us with things. And I know tonight we talked about it, and the topic is going to be on limiting beliefs. But very quick, Bob, I might have left a few things out in your intro, but why don't you tell us who you are and help us out and give us some tips, tricks, advice, and keep us moving forward with our ideas and businesses.
No, that was great, Brian. That's just the way my mother wrote the intro, so that was perfect. All kidding aside, Brian, thanks so much for the opportunity to be here. And hi, everybody. Good evening or good afternoon, wherever you may be calling in, tapping in to from around the world. But really excited to be here for a couple reasons. One is, Brian and I are very, very long-time friends. I've always loved and respected him, and just really excited with what you have all put together here with the Inventor Network. And I have tremendous respect and admiration for all of you. Because whether you're an inventor, an entrepreneur, a content creator, or whatever aspect of invention and creation you're applying here, you have so much of my respect and admiration for what you do, because I know what it takes. As an entrepreneur since 1989 myself, in May it'll be 34 years, which is crazy. I'm really excited in the months ahead to be sharing and unpacking what I call the peak performance formula. And today, in the short time we've got, I just want to share with everybody that there are really 3 core components to high performance or peak performance. The first is mindset, right? And mindset includes things like being clear on your goals and the outcomes that you want to achieve. For 2024 for 2023 as an example, right? So what a perfect time to be really clear on what you want to achieve this year in your business, in your entrepreneurial venture, with your inventions, right? The second is really developing compelling reasons for achieving those goals. We've got to have, really core reasons why within ourselves that ultimately are going to get us to do what's necessary to get those things done. And then things like, identifying, and strengthening beliefs within us that really support us in creating the results that we want most. And then, and finally, around mindset, this idea of really protecting our mindset, making sure that we are becoming excellent at being able to manage our emotional states of mind, regardless of what may be going on in our business, what may be going on in the world or the economy, right? Because the fact is, folks, that mindset, in my experience and my opinion, is about 90% of the game. So mindset is the first piece of the peak performance formula. Then the other components are skill set, right? We've got to actually obviously know exactly what it is that we're going to become really good at, the skill-based aspects of what we're looking to accomplish. And then the third component is execution, right? Got a great mindset, got a great skill set. We've got to execute, we've got to put it into action, and we got to break through things like resistance. So we'll be talking about these things in the months ahead. I'm also, I believe, going to be one of the guest speakers. So we'll really be able to unpack this stuff in depth. So I know there's a lot there to unpack and just kind of touching the surface, but I really look forward to getting into it in depth in the months ahead with all of you. And Brian, thanks so much for the invitation to be here.
Thank you. And Bob, yes, absolutely. We'd love to have you as a guest speaker where, look, we can learn all these things. We can learn patents and prototyping and manufacturing and marketing, but we have to have our minds in the right place. And there's different ways to look at it. So when there's an issue that happens, it's still the same issue. Either you're upset about it or you're going to take it on in a different perspective to keep yourself moving forward. And that's really what you've taught me throughout the years is it is what it is, but what are you going to do next and how are you going to tackle it? So that is something that's really important. And look, as inventors, we go through so many trials and tribulations. I mean, I'm on one of my inventions. I'm on my 7th prototype. I'm ready to pull my hair out, but I see the end result and I see the goal and the vision. So I'm going to keep myself going until I get to what I need it to be. But look, if you're not in the right frame of mind, we get stuck. And that's what we're looking for you to help with going forward, Bob.
Well, and just one last point on that, Brian, because, that's why I say congratulations to all of you, because if you're here, you're either playing a big game right now already, or you're looking to play a big game in your life. You're looking to do something, create something. That's extraordinary. Most people never even think about taking that step, or if they do, they never actually take any steps. The fact that you're here, you're doing it. And when we do that, when we're playing a big game, guys, we are inviting, challenges because, we're going to be outside our comfort zone, right? We're literally inviting, we're in uncharted waters. So things are going to happen that we've never, experienced before. And the bottom line is, like Brian said, it's not what happens. Things happen to everybody. It's how effectively we can deal with them, execute, and move on to the next step in the process. So really look forward to sharing all that with y'all. And I know I'm about out of time. So Brian, thanks again.
Thank you, Bob. Thanks. And we'll see you soon. Thank you again. All right. Very interesting. Look, it's very important for us to have that mindset, and Bob's going to help us throughout the months. Okay. Dale Miller. He is the inventor of Chin-Up Strip. Dale is the most recent National Inventor Club member who is available tonight to join us to say hello. Dale, thank you for becoming a member and premium member. And tell us who you are, where you're from, and maybe you could show us a quick demo of your invention.
Sure. Retired attorney in Atlanta now, originally from Wisconsin. And my inventions kind of fit in line with what Bob talked about, was the mindset and the skill set, because I had to have that kind of thing practicing law, and also in my other love is golf. So if you have a good mindset, you have to have good sleep. So I had to invent a chin-up strip like this. To stop my snoring all night long and sleep better. I fall asleep, I'm breathing through my nose totally. So I get a lot better sleep, turning 80 in February. And the other side of it is I've invented putters. So if you have a good mindset because you slept really well, you definitely can putt better if you have my putter at patentedputting.com. So that's been part of my life for the last 20 years after I retired from the practice of law. And it's been very interesting. And helping people sleep has been very rewarding. And we have resellers, we're on Amazon. We've sold over 10 million of these little strips worldwide. And we continue to roll with it. And my health's been good because I've been sleeping good. Otherwise, I was a terrible snorer, according to my wife. And if I went on golf trips with the guys, nobody'd sleep in the same room with me. I had to pay my own room. So I figured I got to figure this out somehow. So I did with those chin-up strips, and 3M makes them for us. And then we have them die cut and are FDA cleared. So we just keep rolling with it. We now have the chin-up strips coded for Medicare. So that's going to help in the cost for people that use a chin strap with their CPAP machine.
Thank you so much, Dale. I bet you when you showed the demo of the chin-up strip that it was a kind of a 3M tape that goes under your chin and kind of sticks to your face, and you sold 10 million units of them. I'm sure a lot of people thought twice about what you showed them. So congratulations on your success. I have my sample pack coming. You can go to chinupstrips.com and you can check out what Dale is up to. He has a few different versions of it, but I picked up my free sample. So Dale, thank you. And congratulations on your success. And we really appreciate you being our latest premium member of National Inventor Club. I know your t-shirt went out today. So thank you,
Brian.
Thank you. All right, so let's have Matthew Bryan. Hi, Matt. How are you?
Hi, Brian. How are you doing?
Doing good. You know the unmute trick there. Good. Thank you. So, very important topic. Inventors are out there. We know about patenting and protecting our inventions. We know what to do in the U.S. We've heard US Patent and Trademark Office come on, but we may want to consider manufacturing overseas and protecting our inventions. We might want to distribute our inventions in other countries. So we really need help. And we titled this Seeking Protection for Inventions with International Patents. And that really hits home to figuring out how are we going to protect ourselves from really wanting to expand out of the United States. So thank you from WIPO, which stands for the World International Patent Organization. And Matt Bryan is the director of the Patent and Cooperation Treaty Legal and User Relations Division. Matt's going to tell us a little bit more about that and what he does for WIPO. So, Matt, thank you for joining us. You are in Switzerland right now. What time is it in Switzerland?
It is 2:25 in the morning.
2:25 in the morning for us. Thank you so much for being part of National Inventor Club here. You have a very interesting slide deck to go through with us. And by the time we're done, I think people are going to have a really good understanding of what they need to do and how they need to go about doing it. So let me pull up the slide deck for us. And Matt, if I didn't really get too deep into who you are and what you're about, if you could just take a moment to explain what you do at WIPO.
Sure. Thanks, Brian. And it's great to be with you all. Such a pleasure to hear all the other speakers already. So as Brian said, you have my name. I work at a place called the World Intellectual Property Organization. WIPO is one of the agencies of the United Nations. We're based here in Geneva, Switzerland. Like the other agencies of the UN you've heard of, like the World Health Organization and others. And our sole focus is to help create an intellectual property ecosystem that inventors, companies, those who want to protect their innovations all around the world can do so. And so I'm going to take you through in just a few minutes a presentation that talks about one of the treaties that WIPO administers, one that's specifically called the Patent Cooperation Treaty, and how it can be a really important tool for inventors to know about as they seek protection for their innovations in multiple countries. Let me just go forward with that. So as Brian said, if you're seeking to patent your invention and do it in your home country, in the US, where I guess many or most of you are located, then it will be typical for you to seek a patent through the US PTO. We had a previous speaker from the USPTO, Stephen. You would file a national patent application with the USPTO, and that's according to the laws and practices of the US. Of course, you're going to want to make sure that you file that application before you tell anybody about your invention, before you disclose it in any way. That's the normal thing that everyone does, not just US applicants, but anyone in their own home country. But as Brian said, if you're going to potentially look at seeking protection for your invention overseas, you want to at least keep the option open of expanding into foreign markets and maybe getting patents in other countries. Then there's some other considerations you need to keep in mind. One is you need to file any such patent applications within 12 months of the first filed patent application on that subject matter. That's a critical piece of information you need to file away and keep in order to preserve your potential rights. And then there are two mechanisms you can use, and I'll compare the two in just a second, if you're going to seek protection in multiple countries. The two treaties, both of which WIPO happens to administer, are what's called the Paris Convention and the PCT, or the Patent Cooperation Treaty. Firstly, under the Paris Convention, if you have a national patent application, let's say in the United States, but you want to seek protection in Germany for your invention, you have that 12-month period under the Paris Convention in which you would need to file that second German application, and you would claim the priority of the first application, so you get the benefit of that date. That would apply to any other countries also that you would want to seek protection in. So the Paris Convention has been around since 1883. It is the traditional patent system still used a great deal across the world. But another option, and the main one I'm here to talk about tonight, is the one below, which is the PCT system. And one of the main differences between the PCT you can already see and the Paris Convention system is that instead of filing multiple applications in all the other countries in which you're going to seek patents at that 12-month period, in fact, the PCT makes to file one single patent application in one place and in one time with one set of fees, with one office, in one language. And that individual application has legal effect as if you had filed it in all the countries that happen to be members of the treaty at the time. And then there are some other parts of the procedure that I'll talk about just briefly as we go through the slides.
So
But that's
Matt,
one of them. Yeah,
Matthew,
please.
I wanted to ask you, so
Sure.
why would anybody go through the Paris version there instead of directly to PCT?
Yeah, it's a great question. If you have only interest in one or two countries, then perhaps the Paris Convention might be most advantageous on time or on cost, or if you need to have patent protection quickly. You have someone who's infringing your invention in a particular country and you need to get a patent granted to yourself. In both those cases, you might want to use the Paris Convention system. If you want, or if you have a really clearly defined view, you know that the only markets you need protection in are in Japan. So you're going to file in the US, you file within 12 months in Japan, and you know that that's it. There's no other protection you need. If your idea for protection is clearly defined, then you could use Paris, and that's fine. If you're not so sure, if you want to at least keep the options open for a while and learn a bit more about the technical side, the commercial side, the financing side, the PCT in many cases is a better bet.
Thank you. You know what's interesting, Matt, is that,
Yeah.
look, we're working with patent attorneys or agents for the most part. Many of us are. I know some end up doing it on their own, where they're filing their own applications, whether it's utility or design patents or what have you. And it's really important. Like, we can listen to what our patent attorneys or agents say, and hopefully they understand this, because this is part of really the extension of our intellectual property from our home country here. But it's also good for us to be educated, and that's what you're doing tonight, is really helping us to understand what we're getting ourselves into if we want to get into it, and we can have a better conversation when we're speaking to a legal advisor on this. So we appreciate this.
Oh, happy to. And absolutely right. I completely agree with you. You should be as informed as you can be as you go into those conversations. Now, ideally, your patent attorney should be advising you about all of your options, and the PCT should be one option that should be considered in those conversations. But yeah, be better informed, and that's indeed the reason why we're here. And this slide kind of summarizes the answer to the question you raised there, Brian. You would more typically use Paris if you have a small number of defined countries, and if your budget is very, very limited. PCT may have some additional costs past the Paris Convention system, but it also gives you a lot of options and keeps the options open in a huge number of countries to seek protection. And I'll show you those in just a second. If you take all of the what we call non-resident patent applications, applications filed by someone in a country who is not a resident of that country, you add them all up, it's many, many hundreds of thousands of, if not millions of applications every year. And you break those down between Paris and PCT, you can see, amazingly, the Paris Convention, for as long as it's been around, still very widely used for the reasons we just talked about. But the PCT has become, and that graph has changed a lot in the last 25 years or so, almost approaching 60% of all those applications come via the PCT. The PCT has become, in other words, the majority vehicle that is used by innovators when they are seeking protection in other countries. They file a PCT application because they can do it once, as I said, and forget about it for another 18 months before they have to come up with the big costs. So where do you file PCT applications? Well, typically, again, if you're from a particular country that happens to be a member of the PCT, then you could file your application with the National Patent Office. That means for all of you who are in the United States, you can file a PCT application directly with the USPTO in Washington. They accept PCT applications. You can file them with them. You can also file it with us directly here in Geneva, in Switzerland, through our office. And if the country that you're living in happens to be a member of one of the regional patent treaties, like the European patent system, you can also file a PCT application with the regional patent office, like the European Patent Office in Munich. The PCT sets up this timeline where you file an application, you have it searched, you can find out about the potential patentability of your invention. It's going to be published in an international uniform way. There are some optional parts where you can get additional information about potential patentability. And then you have this decision point where you have to decide in which of the countries are you going to actually be seeking protection. And there's some costs that come with that. But to come back to the really critical point where you file the one PCT application that has legal effect in all these countries, this is where that application will have effect. This map shows the countries in blue are those that are currently members of the PCT system. So you file one application in Washington tomorrow, it is as if you had filed regular national utility patent applications in all of the countries that are indicated in blue. That's the legal effect of one application. You can see there are still some countries that are indicated there in gray or white that are not quite yet members. We're working with many of them. We're in discussions with many of them, and they continue to ask for our assistance in helping them be prepared to join. In the time that I've been at WIPO, about 100 countries have joined the system. When I first joined, there were between 50 and 60, and now, as you can see here, we're at 157 countries that are members of the system. So countries constantly.
Wow.
Sorry.
And WIPO. So you're really you oversee everything that's
Yes.
going on with the international patents. There's not other organizations like yours. You're it.
We are pretty much it in terms of intellectual property. There are some organizations that have some pieces of IP, like down the street from us here in Geneva, the World Trade Organization has some IP areas that they deal with. But yes, WIPO is the center of the world really on intellectual property. So this lists the 157 countries. The most recent one to join was just a few weeks ago. Mauritius, the island nation in the Indian Ocean, joined the PCT. And we usually end up having 3 or 4 or 5 countries join every year, which expands your options as an inventor because your application then has potential legal effect in all these countries. This is our attempt to just indicate those who are not yet members, the countries that are not yet members of the system. And in fact, we need to take Mauritius off this slide now since they just joined so recently. This is just to give you a sense, in addition to the growth in the numbers of countries that are party to the system, this also shows the number of applications has constantly gone up. I've been doing this a long time, and it's still surprising to me that in 44 years of operating as a system where you can file applications, in that time, the PCT has only not grown year on year, 1 year. And that was 2009, the global financial crisis, where everything kind of wobbled across the world and companies filed just a bit fewer than they had typically filed, and then right back into the growth trend. So we don't have the filing figures for 2022 quite yet. We're still getting those together, but we're expecting there's going to be also growth. So even during the pandemic, these applications continue to show growth. Where do they come from? Yeah, sorry, go ahead.
Quick question there.
Yeah.
I know you showed the comparison with PCT in Paris.
Mm-hmm.
What about independent inventors or non-company applications? I mean, this is stagnant as it continues to keep increasing. Have you kind of seen that balance?
Yeah, clearly the largest user of the PCT system is businesses, right? Companies. But individual inventors continue to use the PCT system as well. They have always been a very strong component of it. There's a slide a little bit later in the deck that talks about the breakdown between companies, universities, public research organizations, and independent inventors. And it's not a titanic, percentage that are filed by inventors, but it's been stable for as long as I can remember. So always the PCT appeals to the independent inventor community. Yeah.
We got some great questions coming in at the end. Let's see if we can hold them till then, and we'll have you answer some of these. Pretty interesting.
Great. I'll just slide through these really quickly. This just shows where the main number of applications come from. China is at the moment the largest user of the PCT system. For maybe 30, 40 years almost, it was the United States. And just in the last couple of years, China has moved ahead. Japan, Korea, Germany, France, the UK, also big users. Let me just crystallize for you that we could talk for days about how this all works, but the main 2 advantages of using the PCT system. One is that the major costs that you run up against when you're trying to internationalize a patent application gets postponed to a very significant degree if you use the PCT. And let me put a finer point on that. Back to the Paris Convention and the PCT comparison. The biggest fees you're going to face if you're in this space and you're looking to protect your invention in multiple countries are those that come due when you have to file translations of your application into a foreign language, the fees that you pay to the patent office, and probably the largest of any of those, the fees you pay to your local patent attorney in that country, right? So under the Paris Convention system, as you can see, all of those fees become due at this 12-month period per country. If you have multiple countries, you multiply by all the translations you might have to have, and the attorneys and the office fees. And the PCT, one of the things that companies, inventors, universities love the most about the PCT system is that they can file this application at this point, pay some minimal fees here, and the really significant costs get pushed down 18 months later than you would have under the Paris Convention system. In the meantime, you learn a lot about the invention, its potential patentability, and you can make a more informed decision based on the risks that you weigh about whether these fees even need to be paid. right? So that's the single most important thing, is the postponement of the costs. And the second one is, I've alluded to it already, the strong basis for patenting decisions. You get these reports. I won't take the time to talk through all the details of these. These are the reports you would get during the PCT process on the potential patentability of your invention and what has been published out there in the world that's relevant to your invention. So you have all that information up front and can take it into account as you're making these decisions. These are the offices around the world who partner with us in undertaking those reports. So when you file an application with the USPTO under the PCT system, you would select one of 7 or 8 offices that the USPTO has made available to you under PCT, and you would pick one of those offices to carry out the search report. And then within 3 or 4 months of your filing of the application, you'd get those documents I just showed you that would help you understand all the costs and the impact.
Would you end up selecting the country that you're from, or would you do it from the country that you're filing to?
You could do any of those. It could be one that you plan to enter. It could be one that's lowest cost. It could be one where you may have a licensee, or you may have manufacturing. There may be one based on all sorts of reasons, and your patent attorney will be able to advise you on all of the options, and say, just lay them out for you and say, well, this one has these costs, this one has these languages, this one has these particularities. Here are the ones that you have available to you. They'll advise you. These are some other advantages. We won't take the time to talk about them. Here's what I was alluding to a minute ago with Brian's question. Still 87% of the users are businesses. Then you can see individuals still make up a solid 5% of PCT applications. Universities is a growing sector, and then government and research organizations. Just to finish off, again, we're still compiling the 2022 data, but for 2021, it just gives you a flavor of the top users of the PCT system by numbers of applications that were published. You can see this top 15 users very heavily weighted on the tech sector, right? Huawei, the Chinese company, had almost 7,000 applications published in 1 year. That works out to be 26 applications a day that were filed or published. So the R&D that's going on is staggering, right? You have universities are huge users of the system. In fact, the last time I was with Elizabeth Doherty of the USPTO was in North Carolina in November, so just last year. We were working together on a series of lectures at NC State, UNC, and Duke University to help them in their work in using PCT. Then you have public research institutions all over the world, research centers who are also extremely active in using the PCT system because it helps them so much. Last couple of slides, and we'll get to the questions. We have a feature on our website where people can submit success stories about how the PCT helped them get protection for their important invention. And the one we just published just a few days ago, I thought may be interesting to you because it comes from an independent inventor like you all. Brahmadev Sharma has developed an invention about haptics that come through your steering wheel. So you're driving and you can feel certain aspects of the road and feedback from your driving experience. And he says it's been very helpful. The most helpful part was, as I alluded to, extending the timelines for filing applications and extending the timelines for paying the fees, all that time you get, and then the information that you gain, right? So I'll let you look at those. Another inventor, Dr. Nakamura, who won the Nobel Prize, says the same thing, gives us the opportunity to protect while allowing the market to mature, because in that 18 months, you can do market research, you can do technical development, you can do financial research, you can look for manufacturing and partnering and licensing. It gives you much more time to do all those things. Another startup company that we're involved with is based in Colorado in the US that make these solar powered lights. They started out very small and now have done a lot of growth. And they love the PCT because of, again, this delaying of the patent filing costs and allowing this time to test the market. Without it, as Steve says in his presentation here, protecting in international markets would be a really high risk strategy, with having to come up within that 12-month period that we saw huge amounts of money. And lastly, you have the testimonials. You know Qualcomm, they're huge, but they started out with 7 people back in 1985. And they also love the PCT. They're huge users. They were the number 2 user in 2021, filing almost 4,000 applications in 1 year. So just some statements from some big users. I won't go into this, just tells you what WIPO does in this process. We're kind of, as Brian said, the overseer for the whole PCT system, try to make sure it all works. We have a lot of people here at WIPO who work to make the PCT a successful system, which it is and has been. We have a lot of resources on our website. If you have any trouble getting to any of these, you can send an email to the address at the bottom of this slide, the pct.infoline@wipo.int, and our colleagues will guide you to whatever you need or give you answers to any of the questions that you have. You can also call us between 9 and 6 Geneva time. We're 6 hours ahead of you, at least for those of you on the East Coast, and they'll be happy to help you at any time. We have lots of other information and resources there, and just a summary. I'm happy to take any questions you would like to put. Thanks for the opportunity to be with you.
Yeah, absolutely. So let's have you on the screen here. So Matt, just to really summarize things, because I have texts coming in asking questions and other people on the chat. I'm trying to put them all together. So we come up with an idea. We want to protect ourselves here in the US, and then we're thinking about overseas. We may want to manufacture overseas. We may want to sell our product overseas once we end up commercializing it. Maybe we just might be licensing it to earn royalties, and the licensee that we end up working with has international distribution, and we want to protect our intellectual property, because when we license our ideas to a licensee, most likely and most of the time we're renting the rights to our intellectual property for them to manufacture and distribute. So it's our responsibility as a licensor, the licensor, to protect our intellectual property. That's our responsibility in a licensing deal. So how does this really help us? Like, how do we decide on what countries to protect when we're just starting off, Matt?
Yeah, great point. Well, as you said earlier, your patent attorney can advise you, but one strategy for an independent inventor based in the United States to really keep in mind would be filing a provisional application in the United States Patent Trademark Office as soon as you possibly can after you've reached critical mass with your invention. That's at least starts the clock running for you and is very low cost way to enter the system. Within that 12 months that comes with a provisional application, you really should give serious consideration to filing a PCT application. So you file provisional, within 12 months you file PCT. And the beauty of the PCT, as we were just talking about, is that it keeps your patenting options open in 157 countries. And then you have 18 additional months on top of that to see where it goes, see how it develops, learn about the potential patentability that will come in the PCT reports, and see how the financial and the licensing environment creates itself. And then, only then, at the end of what will be 30 months, 2.5 years from the first filing of that provisional, will you have to make an important decision about where are the countries, which are the countries in which I really need protection, I really need a patent. And then instead of 157, it'll be 4, or it'll be 5, or it'll be 3, whatever it is. But you have all that time and all that information and all the advice you can get in that 2.5 years. The decision only has to be made about identifying the countries at that 30-month period. And that's something you wouldn't be able to do under the Paris Convention system. At Paris, you got to go hard, you got to go up front, you got to go at 12 months and jump into all those countries and pay all those fees. The beauty of PCT is this time and information to make better informed decisions.
Got it. So before we get to the audience questions, I have one more here. I guess the text messages are taking priority over the social media here. But if we were going to we came up with our idea and we want to do a patent search.
Mhm.
Do we ask for? I'm trying to translate these questions. So, do we want to ask a patent search to do a worldwide patent search, because we may be protecting ourselves here in the U.S., but it might be not patentable in another country, possibly? So, what's your take on that, Matt? How can we figure that part out?
Yeah, well, I mean, there are tools you can use yourself to do your own searches, but it's always best to get a professional involved, whether that's a private search company or whether that's the USPTO when you file. One positive thing about the PCT is that within 3 months of filing a PCT application, you will receive a worldwide search on potential patentability of your invention. It will look into all of the published patent applications, published patents, technical literature from all sorts of technical areas, and they will spoon feed it back to you and say, look, these are all the documents that we identified that are the most relevant to your invention and that might either potentially be problems for your potential patentability, or documents that are just the closest, but they don't present a particular issue. And that's a real benefit at 3 months from filing. So you're only 15 months into the patenting process, and you will have received a very high quality report from one of the biggest, most sophisticated patent offices in the world to give you a sense of where this is. So that's, of course, you could do it yourself, you could do it privately, but one added benefit of PCT is you get that search, a multinational search, within a very short amount of time.
Got it. All right, so let's see how many questions we could get through here.
Yep.
First, relevant to what you're saying, Robert Simonisky said, Matthew, you might want to mention Article 19, Option 2.
Yeah, thank you. Thanks, Robert. So the point Robert's making, the Article 19 of the treaty is about amendments to the application. So if you get a search report in that 3-month period we were just talking about, and the prior art that is identified, the documents that have been published that are important for understanding the potential patentability of your invention, show that maybe there's some issues that in light of some of these documents, some aspects of your invention may not be patentable. There is an option in the PCT to amend your application, to amend at least the claims in the application and have those claims published together with the rest of the application. This may be important for you to do. It's not used terribly much in today's PCT, but it definitely is an option to amend and then move forward. And there's another option in another part of the PCT procedure where you can amend the rest of the application. But Robert's point is that you don't have to be stuck with what you filed. You can amend the application as you go and as you learn things about potential patentability.
Thank you. We have Rick Lunefeld. He says, hi, Brian and all. If you file in the PCT system, where do you go for enforcement in the event of infringement by a competitor? In other words, which forum has jurisdiction in the event of infringement?
Yeah. Rick, when we're talking about patents, some of us would like it to be different than it is, but in fact, patents are territorial. And they start out being country by country. There are some regional patent systems that I mentioned, like the European patent system, but the PCT does not mess around with that existing system, which means the PCT is a patent application filing and processing system. It is not a patent granting system. There's no such thing as a PCT patent or a global patent or a world patent. Those don't exist. So what will come out of your seeking patents, ultimately, whether it's through the national system or the PCT, will be a national patent in a country, or in some cases, a regional patent. If you're in a place like Europe, you can opt for that.
Thank you. And we have Ellen on LinkedIn. She's asking, what are the fees with PCT?
Yeah, thanks, Ellen. When you file a PCT application, like you would at the 12-month time limit, there are 3 sets of fees that you will pay at that time. One is a small administrative fee to the office where you filed it. So if you file with the USPTO, they have a minimal fee you pay to them for the administrative work they do. The second fee is a portion of the fees that comes to us at WIPO for the overall administration of the PCT system. And the third one, and usually the largest of the three chunks, is for the search that's carried out that Brian and I were just talking about, the search reports. For a garden variety PCT application, again, without any reductions for electronic filing or anything like that, you're looking in the neighborhood of $3,000 US to file a PCT application. That isn't necessarily the case if you're using certain searching authorities, but just as a thumbnail to give you a sense. And then, as I mentioned, the largest of the fees are those things for translations and national phase entries that you'll hit later on.
Thank you. I see Joe has a couple questions, just kind of going through. I think we mentioned the first one. So how is it governed? Are there penalties imposed if somebody does infringe or a company infringes on your IP in another country?
Yeah, all of that is governed by the national patent system of that country. You would have to go to a court in a particular country, even if you get a patent granted in that country. So the PCT does not get involved in any of that. When the PCT was agreed in 1970, it was a compromise, as many treaties are, as much legislation is. And the part of the compromise was the PCT would stay out of the issue of sovereignty about patents and what is patentable in a given country. So the PCT sets up these standardized mechanisms, but what is patentable and what is infringed, courts, enforcement, all of that is left completely to the national governments and the courts in those countries.
Got it. Okay, above the sun on LinkedIn, what if your patents are over a year old? How do you file with WIPO?
Yeah, that's a problem above the sun. If you filed your first patent application and more than 12 months have passed, it's going to be very difficult for you to file and claim priority of that first application. You can still do so, but it may turn out that your first application may become prior art against your second application. This is something you're going to want to talk to a patent attorney about, or to send us an email about, and we can give you more details about your particular situation. There are some, if you're within a particular window of the 12-month, like 12 plus 2 months, there are some options you can use. If it's past that, it's very difficult to validly file and claim priority.
Okay. Ron, is there a contact email at WIPO to ask possible follow-up questions? You had
Absolutely.
that slide up before.
It was in that second to last slide, right there at the bottom of that slide, pct.infoline@wipo.int. These are colleagues who all day, every day, sit there and wait for you to call them and send them emails, and you should get a response from us in 97% of the cases within 24 hours.
Look, for us, Matt, we need to know this. We need to learn and understand our options, because when we're working on our inventions, it's one thing to have and I always say this, the emotional experience of being excited about it, wanting to earn from it and other people using it. But on the other side, you want to protect it. If you have a chance to protect your intellectual property and expand your protection in other countries, if that's what you choose to do, then these are the options. And just being able to have a more educated conversation with who you need to protect yourself is why we do this.
Absolutely.
And this is great, valuable information that we can keep on in National Inventor Club archives, that when you decide at one point, or somebody you know or you need to help with filing overseas or international, that you can reference this presentation.
Any doubts that any of you have out there, any questions, send it to us. There's no cost for contacting us, either by phone or by email. My colleagues and I at WIPO, I have to say, we so admire the courage that is part of being an independent inventor. And you guys make the world go round because it's your inventions that change everything we're doing in the world. So, and that's why we do what we do, is to help innovators seek protection for their innovations.
Now, real quick, Matt, first off, WIPO.int is an amazing resource for inventors. You really simplify the steps and the activity that needs to get accomplished, just like you did today in your presentation. But there are so many amazing resources that are on there that I take and reference in my newsletters and other things that I do when I'm talking to inventors to be able to help them to make decisions on if they're going to file. So WIPO.int, just like we all go on to USPTO.gov, they have great information too, and it's official. It's from a government agent. Well, is it a government agency? Can I call it that?
Well, we're part of the United Nations. So yeah, in a way, we're an intergovernmental organization because WIPO has 193 member states, of which the United States is one. But again, being part of the UN family, yeah, that's great to hear, Brian. We're so glad that these resources are available because all of our member states, all the members of the UN come to us with the same concerns, and there are independent inventors in all of those countries. And the one difference with us is that we have to make it available in all the languages. So you'll not only get things in English, but in the PCT context, you'll see all of our pages are in 10 languages because those are the languages in which applicants file from our country. Most everything else on WIPO's website is in 6 languages. We have to also aim it at the big companies, the small and medium-sized enterprises, and the independent inventors in order to cover everyone around the world who's doing exactly what you and your members are doing, trying to make the world a better place.
I feel bad. I don't want to leave a couple of these inventors hanging. If you have time for one or two more questions.
Yeah, no problem.
Thank you. So Ron, I know this is kind of a continuation, but this may, let's see how quick we could get through this, Matt, but this may preclude patenting in foreign countries. Why is this so? Would you please elaborate?
But this may preclude patenting in foreign countries.
Yeah, this was from Ron. Oh, here's his earlier one.
Okay.
Yep. So he said 1-year grace period for PPA and PCT applications. In the US, a provisional patent application can be filed up to 12 months following an inventor's public disclosure of the invention. And then he said this may preclude patent in filing countries. Why is this so?
Well, the public disclosure is what I think he's focusing on there. There are the United States and a number of other countries have something called a grace period. We're getting outside the PCT. We're getting into substantive patent law, but and your patent attorney can tell you about this. But in some countries, it's fine to file a patent application within 12 months of a disclosure. You went to a trade show, you hadn't filed an application. You disclose the invention within 12 months. You could file, and you're fine in the United States. But there's a number of countries out there who do not have such a grace period in their national law. They don't allow for disclosures that are kind of grandfathered when you file the application. For them, it's if you've disclosed it, you've disclosed it. And that is what precludes or can preclude patenting. The whole world does not have a uniform system on this issue of grace period and disclosures. That's one thing that WIPO would love to get agreement on, but we haven't been able to get agreement among all of our member states yet on that issue.
Got it. All right. So let's just see if we can answer Augustine's question. Please confirm this by the filing of an international patent application under PCT. Applicant can simultaneously seek protection for an invention in several countries.
Confirmed.
Yep.
that is the whole thrust of the PCT system. It provides you a way to simultaneously seek protection, at least theoretically seek protection. There's nobody out there that is going to ultimately patent in 157 countries. Nobody has pockets that deep. But the beauty of PCT is it keeps all those options open to do exactly that, to seek protection in as many of those countries as you have resources to seek protection in.
Excellent. All right. So, Matt, you have inventors at all different stages of their invention. They're just starting off, or they have an idea in their head, or they're manufacturing or figuring out if they're licensing or manufacturing. Just some final words of wisdom from you, because I know that you've been involved working with innovators and inventors, independent inventors, quite a bit. So whatever words of wisdom from you, we appreciate it.
Thanks, Brian. And it's been great to be with you. Yeah. Number one is file before you disclose. Again, don't risk those protection in those countries that don't have a grace period, as we just talked about. Make sure that before you disclose, you file at least a provisional application in the US that you can then use to springboard for protection. Secondly, and I know it's a cost, and I know for some people it's a sore subject, but a patent attorney, a competent registered patent attorney, will be able to advise you on all of these options. And the third thing is try to inform yourself. Like Brian said, our website is one great place to start. We have a lot of resources, not only aimed at the really sophisticated users, but we have a page that is called literally "Are You New to the PCT?" And that will take you through a whole series of steps, introducing you very slowly and very gradually into the levels of detail about how this system works. So those were designed with you in mind, with those who don't know it as well. And then keep in touch with us. WIPO, as Brian has said several times, exists to be a resource, to be helpful to you. We're part of the UN family and UN system, and the only reason WIPO exists is not as a profit-making business. We're completely the other way. We're there to help. So if you have questions, you have doubts, you have concerns, you're not sure if what your patent attorney is telling you is the right thing, feel free to check in with us. Send us an email. We're happy to be a resource for all of you and accompany you on your inventing journey.
Thank you so much, Matt. Really very grateful for you being up at, I think it's 3 a.m. now. So
It's all good. It's all good.
It makes you feel like you're back in the US.
That's right. That's right.
Right? You're in a different time zone, but all the way from Switzerland at 3 a.m. to educate our independent inventors, resources for inventors out there, just people to be able to be well educated, have a little bit more of an edge than other people, to be able to have better conversations with our patent attorney or agent, and just for our own self to know what our options are. So very much appreciate you and your colleagues for doing an amazing job. WIPO.int is Matt's WIPO website, and you can really get some basic information all the way to detailed, and his office is extremely resourceful. I've been trying to get WIPO on for almost a year. Thank you, Elizabeth Doherty, for connecting up Matthew here with us, and hopefully this information is just as valuable to the everybody watching. So thank you again for your support.
Thanks, Brian. So happy to be with you all.
Thank you. All right. This concludes another month of National Inventor Club. For those of you who are premium members, you received a Zoom link for our after meeting networking. Let's hop on there for a little while and talk about tonight's speakers. Let's help you if you have any particular challenges with your invention. Let's talk about them together. We have a good group that comes on afterwards. So please, if you'd like to become a National Inventor Club member, there's a premium membership, which is $129 for the year. There is the free membership, which of course you're welcome to join in that regard. And everybody, just keep on moving your ideas forward in 2023. We've had some great information: Small Business Development Center, US Patent and Trademark Office, Bob Quintana, the #1 Tony Robbins trainer back in the day, and now he's with us, National Inventor Club. Let's see if we can get him as a speaker for next month. Thank you, everybody. Keep on making your ideas and dreams a reality and keep them moving forward. Till next time, from National Inventor Club, good night.